this video on client interviewing. Now, client interviewing is an essential legal skill. Even if you decide that you don't want to be a criminal lawyer or a lawyer that's involved in litigation of some kind, you're still going to have client contact. Even if you're a transactional lawyer who mainly focuses on conveyancing and property settlements, or a tax lawyer who mainly focuses on figures, you're still going to have to deal with clients' instructions in relation to their matter. So you still need to meet clients for the first time. You still need to identify what their legal issue is or what they want you to do on their behalf. So on that basis, it's a skill that you need to learn, and it's a skill that you can't avoid. You will therefore have some contact with a client on a daily basis. And note that clients are not just looking for you to listen to their story. They often want practical or tactical advice, as well as information about the law and how it applies to their case. So the importance of this skill for lawyers in legal practice is one of the reasons why we are focusing on this in a core law unit. Now, my first and perhaps the most important tip is to prepare. You may, during work experience, or perhaps if you work in a law firm, have experienced a situation in which a lawyer has gone into a client interview. Perhaps it's a new client to the firm and they don't know much about their dispute, and so they've gone in with very little preparation. You're not in a position to be able to do that yet. Until you are an experienced lawyer who is seasoned in the art of client interviews and an expert in the relevant area of law that the client wants to talk to you about, you need to prepare for the interview. Otherwise, you'll miss key things in the client's story. And of course, if you don't have a plan in place, it's likely that the interview will go over time and you won't have necessarily covered or focused on all of the aspects that you need to. Now, usually, even if the client is new to the firm, you'll have a rough idea of why they want to see you. Usually when a client books an appointment, they say that they have a contractual dispute, or it's in relation to a conveyance of a property, for example. Now, that doesn't mean that it's definitely on that area. Sometimes clients are not able to identify with precision what their legal issue is, and as you talk to them and the story unfolds, you realize that actually the issue is much larger, or is actually related to a different area of the law. Having said that, as you've had an indication of the area you should prepare, you'll need a working knowledge of the area of the law and the processes related to action in that area. You should also consider whether you can ask the client in advance of the client interview to bring something that's relevant to the interview. So for example, if you know it's in relation to a building contract dispute, say the client has fallen out with their builder, you can ask them to bring a copy of their building contract with them, or send one to you via email in advance of the client interview, so you've got an opportunity to read and digest what the terms are. If you've seen the client before, then it's really important to consider what's already on the client's file. And that includes any work that has already been carried out on the file by other lawyers. For example, another lawyer may have seen the client initially and provided initial advice. You'll need to review their memo on the file as to what was uncovered and what was advised in that particular instance, and have that information in your mind when you're preparing for the client interview and conducting it. On a practical note, you would also in practice need to consider whether or not you need an interpreter for the client, and there's a section in the study guide about that. Now, when it comes to actually conducting the interview, you need to ensure that you don't just conduct a regular or generic client interview, where you've got this specific client interview that you roll out for each client. It's generic, it doesn't change, because that is not going to necessarily identify all the things that you need to explore with the client in terms of their story or in terms of how the law impacts and applies. Note also that each client has different objectives, they have different goals, and they have different needs. Some of those goals and needs may be dependent upon finances. So it's really important to look at the client as an individual and ascertain what their problem is and the broader implications of any action that the client might take, including both legal and practical implications. And of course, being responsive to the client's needs and objectives also involves considering whether there are any other referrals that you can make on their behalf, with their permission, of course, such as referrals to relevant local authority services who may be able to assist them in relation to their dispute or more broadly. Often a client's dispute is made up of legal and non-legal issues, and sometimes it's outside the remit of the lawyer to be able to help with the non-legal issues, but that doesn't mean that we shouldn't consider referring them to suitable support services. An example might be a client is homeless and their inability to secure permanent accommodation means that they are not a suitable candidate for employment, and that of course has led to them not having sufficient food, and that causes them to steal from, say, the local supermarket. In such cases, dealing with their case before the magistrate's court is of course what legal aid has paid you to do, but a holistic approach that looks beyond the client's legal problem and looks at their general need and their general circumstances would suggest that referrals to suitable support services in the local area may also prevent the client from being in this position again in the future. Now, of course, there is a limit to what a lawyer can and should do in terms of ethics. We cannot become deeply embedded in a client's life and offer them the kind of support that a social worker or a counsellor might do. And in fact, we're not qualified to do that. We haven't spent years at university studying psychology. But recognizing that your client's issue is not just a legal one and that their specific issue is different to the next client's because they have individualized circumstances that are impacting upon their life makes you a more empathetic lawyer and also ensures that you deliver a client-focused service. Now, for our purposes in this unit, we're focusing on initial client interview, so where the client is brand new to the firm, you don't really know anything about their dispute, and you need to find out more to be able to ascertain how you can help them, if at all. In these situations, the primary purpose of the interview is ascertaining what the client's legal issue is, what the relevant facts are, and the client's objectives. Sometimes preliminary advice is also provided in the initial client interview, but this is not the primary objective in meeting the client. Note that when you first meet the client, they may be anxious and reluctant to reveal information. They might be stressed, or they might be naturally reserved. They could be at the other end of the spectrum and be overly talkative and provide you with way too much information at once. Each person reacts differently to the strange situation of being sat before someone that they don't know and telling them a very long story. But one thing that they will all share in common is that they need you to build a rapport with them so that they can trust you and provide you with the information that you need to be able to advise them. In other words, you really need to build a rapport and help them relax into the client interview. Otherwise, you're not going to get what you need, and the client is going to go away feeling like they weren't listened to, or that perhaps you're not the lawyer for them. Now, as the study guide outlines, initially you want to use open questions to allow the client the scope to tell the story from their perspective. If you hone in on the story too early and start asking very narrow questions, the client may not tell you something that's actually quite important and quite essential to their story and their legal issue. So you want to start with open questions with minimal interruptions, so that the client feels listened to and that they can trust that you will listen and work with them through their story, and also so that you can get a general overview of the facts. Some clients who are nervous or anxious will perhaps blurt out information rapidly at you. Others may be reserved and only tell you bits of the story that they think are important, or they might be reluctant to tell you information that puts them in a bad light. In all these cases, you'll need to control the interview to some degree so that you can gain the information that you need, but try to avoid narrowing in on their story and asking closed questions right at the outset, because you may miss something important. One of the ways that you can help the client in these situations and control the interview but still provide scope for them to tell their story is to just take them back to bits of their story slightly later on in the interview, so that you can get more details, saying something like, if I can just take you back to the day of the accident, before the accident occurred, you said, and remind them of what they've said, and then ask them questions that break down what happened. That's particularly important when the client just gives you one sentence about each thing, and you need to know more about witnesses, or you need to know more about what the parties talked about when they were negotiating their contract, etc. In such cases, what you're really doing is coaxing them into giving you the information that you need to be able to fully advise them. So keep the questions as open as possible, even when you do take them back to particular things that you want to focus on. So for example, you could say, I just want to go back to the argument that you had with your neighbour. You said a minute ago that they were aggressive towards you, but you didn't tell me what that meant. What do you mean by that? So you can see there that I've not fed them suggestions as to what aggressive means, and I've opened it up to allow them to describe the demeanour of their neighbour. And of course, if they just describe that he or she looked angry or were aggressive in terms of their stature, you might ask them then at that point, did they say anything or behave in a particular way? In those instances, you are in effect at that point narrowing further, but give them the scope in the first instance to provide you with more detail through an open question. As you focus in on specific important aspects of the facts, and after you've given them the opportunity to still elaborate further through an open question, at that point you can then narrow the questions down, and that's called funneling. So you're funneling towards trying to get the information that you specifically need from the client at that point, once you've got a very good understanding of the background facts. Now, it's also important to remember in a client interview that you need to think about more than just the background area of law that applies to the client's legal issue. You need to also consider what information or evidence might be relevant to this particular issue. So, for example, let's say that we've got a commercial client who comes to the office in relation to a delivery of faulty products to their premises. They're obviously alleging that the seller breached the contract between the two parties by delivering these faulty goods. Now, if you identify that there is actually a clause in the contract that permits the seller the opportunity to redeliver once the buyer has complained about faulty products, you would want more information about that, and that information would extend beyond what the client says happened. You would want to think about what evidence you can gather in support of that discussion that took place between the parties, and that shows that the seller has had the opportunity to redeliver the product. So, for example, there may be emails or other forms of communication passing between the parties about that faulty delivery and about the opportunity to reattempt delivery. You therefore need to ask your client to provide you with those emails or other forms of communication, because those communications will be evidence relevant to the legal issue between the parties. Once you have all the information you need and you think that you have a good understanding of the facts and the legal problem, at that point you need to summarize the facts for both you and the client so that you both share the same understanding as to what the material facts are and what the legal issues are. Now, when it's time to close the interview, one of the things that you must do is summarize for your client what the legal issues are and the range of options that are open to them at this stage. There may not be many. It may be that you need to go and conduct some legal research and provide a letter of advice, but there could be lots of other options available, including, for example, writing to the other side or making further inquiries with, say, the local council. So at that point, you need to summarize what their options are and also check whether the client has any questions. You will then need to address costs with that client, reminding them that although this interview is free, any further work on the file will incur a charge. Now, a tip here is to not be afraid to provide the client with a list of things to do, such as sending you copies of important documents, and it's best to provide them with a date to do that by, otherwise you may be waiting for those documents for a very long time. If you have provided the client with advice, make sure that you summarize it before you close the interview and check their understanding. The same is also true in relation to any instructions that they provide at this point in time. Check that both parties understand what you will be doing on the file. My final top tip for a client interview is to actively listen to the client. Now, we may all think that we actively listen, but actually in the world of Zoom meetings where we can actually do two things at once, such as typing on our keyboards whilst pretending to be part of a meeting, and in a world where we talk to people but also message on our phone at the same time, we actually aren't great at active listening. We actually need to work hard to ensure that we're actively listening to others. The story is important to your client. They've come to see you because they're aggrieved by the situation in some way. Their story and their legal issue has impacted them to such an extent that they've taken the step of coming to see a lawyer about it. It's therefore important that you respond in a manner that makes them feel like you are intently listening to them. Active listening involves showing interest in their story and also acknowledging their story when appropriate. Now, research has shown that we generally watch YouTube videos for 7 minutes or less. So in this media-driven age, when we're used to quickly scrolling through information, clicking out of videos after a couple of minutes and moving on to the next thing, and we're quite used to talking at speed and messaging at speed in a casual manner over messaging apps, it can feel quite unnatural to sit for 20 minutes, half an hour and talk to a client. It's something that you need to practice though, as most client interviews are a minimum of 20 minutes in length. Remember that the client is paying you to be there or is a prospective client, and therefore they expect you to listen and be present in the moment when they're telling their story. Okay, that brings me to the end of this video. I hope it's been helpful, and I'll see you in the workshop.